Fifth District Court of Appeals in Dallas, Texas is now in session. Justice Peterson presiding.
Thank you very much. First of all, let me apologize for the delay. We had another oral argument immediately before this one that ran long. It could not be avoided, and we appreciate y'all's patience. Case number 0519-00817CV, Anubis Pictures LLC and CMA Films LLC versus Philco Films Productions Limited et al. Both sides present and ready?
Yes, Your Honor.
Yes, Your Honor.
I don't know if y'all are familiar with our timer system. One of your screens has a timer on it. The appellant will have 20 minutes. When it get down to 3 minutes, it'll be yellow. When it turns red, please finish your sentence or finish responding to a question from one of the members of the panel. Otherwise, when it turns red, please stop. And then the other side will have 20, same warnings, and then the appellant will have an additional 5 minutes at the end for rebuttal. Any questions?
Your Honor, if I might, I'm a cross appellant and I would hope to get 5 minutes at the very end.
Well, we're just going to do 20, 20, and 5. I apologize. Typically, if you want to deviate from our normal time period, typically that's handled with a motion, but I'll give you a little more time at the end if you need it. If you find yourself needing just a few more minutes, just let me know, and I'm sure the panel will indulge you. Okay, well, the appellant is represented by Mr. Goldfarb. Mr. Goldfarb, you may begin whenever you're prepared.
Thank you, Your Honor, and may it please the court. This case is about one of the last unmade scripts from the great Stanley Kubrick. Phil Hobbs, who was Mr. Kubrick's son-in-law, met some people to attempt to get financing to produce the film. And that group, the FCTVA group, contacted my client, Anubis. Anubis met with Philco, which was Mr. Hobbs's company, and with his partner and negotiated a binding letter of intent to finance the film. As part of that, I guess I should start off by saying there's a couple of issues in the case. I know the court has read the briefs. It's a summary judgment case. We contend summary judgment was not properly granted in this case. There's an issue as to the special appearances filed by Mr. Hobbs and his partner, Steve Lanning. Those matters are fairly straightforward, and I'm going to let the brief speak to the special appearances unless the court has any questions. And I'm going to concentrate my argument on the motion for summary judgment that was granted as to Lauren Selig and her entity Shake and Bake, and to address the issue of sanctions, which was raised by the cross appellants. After Anubis met with Philco, they negotiated and signed a binding letter of intent in which the parties intended to have full force and effect. That letter of intent called for making the film in Dallas. It discussed the fees. It discussed the method for financing. It handled the material terms. The principals at Anubis, including Jonathan Brownlee, knew Lauren Selig, had an existing NDA with Lauren Selig and Shake and Bake, under which they had discussed prior projects. Under that NDA, Anubis provided a copy of the script to her, as well as information about the project, including the actors who were involved in the discussions, including Matthew McConaughey, Joaquin Phoenix, the director who at the time was attached, Jay Russell. All of that information was provided under the NDA to Ms. Selig, and there's evidence in the record that shows that this was done with the expectancy of confidentiality. There's evidence in the record, not only emails, but there is affidavit testimony about a telephone call that took place between Ms. Selig and Mr. Brownlee, where the issue of the terms of their agreement for getting the project financed were discussed and agreed to. The terms of that, the material terms of that, including the equal sharing of fees, how people would get producer credits, and what would happen were all discussed and addressed. A draft was sent off to her lawyer, and there's evidence in the record reflecting that agreement had been reached. That proposal, I won't call it the proposal, the documentation on that was never rejected. Instead, the parties moved forward. Ms. Selig asked for permission from Mr. Brownlee to share the script confidentially with other people in the industry to try to move the project forward. That's consistent with the terms of the NDA. Ms. Selig represented to third parties that she was working with Anubis to get the project off the ground and financed. And she confirmed that she was going to, get the project funded. All evidence in the record, at least creating a fact issue showing that the parties had a deal.
So Mr. Goldfarb, just to make sure I understand, so there is a written contract, which was the NDA, and then there was a verbal contract, which was the LOI. Is that your allegation?
Let me just to be clear, with respect to Ms. Selig, there's a written NDA, that's in writing, that's at the record, that's in the record. I've got a copy of it here. I realize I don't have the actual record site to the NDA, but that's in writing. There is, I apologize, Judge.
No, I was going to say that, well, it's hard to read because the record is covered up by the base number. But
okay, yeah, I see it right there. I see the base number, but the record number is covered by the base number. That's what I'm having a hard time with.
Yep,
I can get that. Actually, the NDA, I think it's 863, excuse me.
I think that's right.
863. There is a signed LOI between Anubis and Philco. Yeah, it's covered up by the number 2.
Right, but not between Anubis and Selig.
That was in writing and sent to her lawyer, but was not signed.
Right.
But there is an affidavit which talks about the telephone call, at which point, my client testifies that the parties reached an agreement, and in the emails back and forth, it states agreement has been reached. This shouldn't take long to get finally documented.
Mm-hmm.
With that, Anubis introduces Ms. Selig to the people at Philco. Ms. Selig has denied that. She claims that she met Philco independently of Anubis through the director at the time, Jay Russell, because she knew Jay Russell. Our evidence in the record shows that we told her that Jay Russell was attached and that she went to contact Jay Russell. But regardless, she contacted Philco, and at that point in time, they have a conversation between the two of them where they agree to cut Anubis out of the project. And that's in the record at 2230 to 32. There's evidence that there's a trip to England that Ms. Selig takes to go meet with them. In the course of that, she acknowledges to the people at Philco that Anubis brought them together and at the very least deserved a finder's fee. And that's at 2231. We brought claims against Ms. Selig in contract and in tort. And I just want to walk through those claims and the defenses that were raised to them and the fact that those defenses do not merit summary judgment as a matter of law. First, we brought a claim based on breach of contract under the NDA. Selig raised two grounds to oppose that.
Sir, before you get,
First,
sir, Mr. Goldfarb, before you get into Ms. Selig's response, could you explain precisely how your client alleges that Ms. Selig breached the NDA?
Under the NDA, including paragraph 2F, the information provided to Ms. Selig was to be used solely for purposes of the discussions between Anubis and Selig. It was not to be used for other purposes. He wasn't allowed to circumvent Anubis. So while the contract states that there is no obligation to complete a deal by virtue of receiving confidential information, she's not allowed to receive the confidential information and then use it for her own purposes or purposes separate from the discussions. That's exactly what she did.
And what are Anubis's damages for her breach of 2F?
The damages are the damages that Anubis would have had for being able to participate in the deal and get the profits from making the last Stanley Kubrick movie.
Please identify where you those damages in the record. Like, what's the number?
We have evidence in the record regarding those damages from the context of the default judgment, but there was not a motion for summary judgment on the basis of no evidence of damages. That was not the grounds of the motion.
Mr. Goldfarb, on page 265 of the clerk's record in paragraph 42, they'd filed a motion for summary judgment. They called it a, let me see, 265. They called it a, let me see where it is. That I believe they said that on all of your claims, you have no evidence of damages in the motion for summary judgment. And in footnote 1 of the plaintiff's response, you state that the issue of damages is not before the trial court. One, I don't understand why they're not before the trial court. And two, I'm still waiting for you to identify like a number, or you describe the damages as what she would have made. What is that number?
Well, you got two questions. I don't know which one you want me to get to first. On the breach of contract claim in the motion, they did not move on the basis of damages. I'll have to look up the pinpoint site that you're referring to because I'm in the middle of argument.
It's the last paragraph of their motion for summary judgment. Finally, as to all claims, plaintiff cannot meet its burden of establishing damages. And I don't understand why that wasn't before the trial court.
The testimony regarding the damages is at clerk's record 856, paragraph 17 to 20.
All right. 856. Thank you.
And, the issue regarding the motion on damages from the original motion.
Mm-hmm.
At the time that original motion was filed, there was an issue with respect to discovery and whether the movement was going to be moving on all claims or just some claims and what the scope of discovery was going to be. And the argument came back, we're only moving on this claim. It was whether you're going to move on contract or you're going to move on everything. Do we get discovery on everything, or are you going to limit discovery? And they opted to limit discovery and go with respect to the breach of contract case. So if you look at the breach of contract claim under the motion, that's what was addressed. Then later on in the case, we talked about other issues. But when the breach of contract claim was resolved in the first summary judgment, it was on the basis that I'm addressing with you now, not on the issue of damages.
But your damages evidence is clerk's record 856, paragraph 17 through 20.
Judge, if I may, it's very difficult to do this in real time. May I submit a letter with the exact pinpoint site on damages?
That'd be very helpful. Thank you so much, Mr. Goldfarb. And I'm sorry for interrupting your presentation.
I want to be responsive, and we'll submit a letter brief with the pinpoint site to the record.
Thank you.
Seeing how much time we have, I want to hit just a couple of things quickly. One, on that motion, there was an argument that it didn't apply to this project. It only applied to a project called Mantivities. They're relying on extrinsic evidence for that. That's not permitted under the parole evidence rule. Second of all, the exact contract doesn't limit it to that project. The evidence in the record shows that there was additional information that was provided after that project and that the parties treated it as confidential. Second, the argument that they made in the trial court was that the project itself was not confidential, that the existence of the fact that Stanley Kubrick wrote this script was not confidential, but that's not the issue here. The issue is they got the exact script, they got the people involved, they got the business strategy involved. Those things are confidential. At least there is evidence in the record that that's a fact question. Later, they raised an issue as to whether or not there was a condition precedent based on paragraph 7 of the NDA. We presented evidence that subsequent to that, there was actual performance. The parties can waive that. There is evidence of waiver and estoppel on that. And we cited the Foreca case and the Commission of Texas versus Gulf Energy case to establish that. With respect to the breach of contract on the terms of the deal, the LOI, there is evidence of a verbal of agreement. It was not proper to not consider that. That evidence supports a fact question. The response to that from Ms. Selleck was that Mr. Brownlee's testimony was not credible and that it somehow conflicted with hers. That makes this a he said, she said, and a fact question. In addition, if their argument is—
a question for both of y'all. You've got two theories. One is breach of the NDA and the other is breach of an actual deal. Do you have to have the actual deal if you have a fact issue on a substantive breach of the NDA that led to their not, because they breached the NDA, that's why there wasn't a substantive deal? Does that make sense?
I see what you're saying. I think that there may be issues of overlapping damages, but they are two distinct theories. Okay. And if the issue is that, for example, that the NDA didn't apply to this deal, then of course, paragraph 7 of the NDA wouldn't apply to this deal and you would have an oral agreement and you wouldn't have the condition precedent. So I don't think that it's, we can prevail on either one of these. The evidence supports both.
Okay.
We have just a few minutes, and so I want to talk very briefly about what the breach of fiduciary duty claim. The motion on the breach of fiduciary duty claim did not address our formal breach of fiduciary duty argument, our cause of action. The motion did not address it. Therefore, it is improper to grant summary judgment on it. Since there was no motion directed to it, it was only directed to informal fiduciary duties. The evidence shows some evidence on the elements of section 152.052A regarding what you can show to show that there's a partnership or joint venture. With respect to the defense of the fraud and the promissory estoppel and other representation claims draws heavily on one email pulled out of context in which Selig says that we did not rely on her because we could have tried to get financing from somebody else. That is not dispositive as a matter of law over our claims. It pulls it out of context. The fact was we were moving forward with Ms. Selig based on her representations and her conduct that she was going to be our partner to get this done. And we were honoring that. The fact that we could have gotten financing someplace else if she had told us she didn't want to do this doesn't undermine our claims against her. One final point with respect to the motion for sanctions that was filed against my client and me for more than $1 million in this case. There is no evidentiary record made on the motion for sanctions. The only evidence was one email that had to do with scheduling because counsel was difficult in attempting to get something scheduled with respect to the Jewish holidays. There was another issue with respect to my associate whose father was gravely ill, and there were problems with scheduling, and there were difficulties with counsel agreeing to that. The law from the Supreme Court and this court is clear. If you want to seek Rule 13 sanctions, there has to be an evidentiary hearing, and there must be evidence taken on the elements that must be shown to prevail. There was none. Nevertheless, they insisted on pursuing this appeal despite a slew of cases from this court which say you have to have an evidentiary hearing, and they put us through the ringer on it. I appreciate that Rule 45 is not used frequently, but this is one of those cases where it is appropriate. It is the only remedy. There was no basis to bring that appeal. We filed a motion, we presented the authorities, and they cannot cite a single case to this court where an appellate court held that it was an abuse of discretion not to issue Rule 13 sanctions, especially not in the context of a case like this where there is no record.
Thank you very much.
Sanctions.
Mr. McDowell, whenever you're prepared, you can proceed.
May it please the court, I'm John McDowell. I'm here representing defendant appellees Lauren Selig, Shake and Bake Productions, Stephen Lanning, and Philip Hobbs. I also represent defendant cross appellants Lauren Selig and Shake and Bake Productions. Anubis pretended to be things that it was not. First, Anubis posed as a financier to try to get an agreement with Philco, but Anubis never had the $10.5 million that's recited on the face of that LOI. Philco, in contrast, actually was the company with actual access to the rights to produce the Stanley Kubrick movie Downslope. Second, Anubis posed Ms. Selig as an experienced producer with the exclusive way to the Kubrick movie. But Anubis was neither experienced nor had the executed exclusive they promised. Anubis literally had been incorporated for 2 months when it made these representations to Ms. Selig. Ms. Selig, in contrast, is a person who actually does get movies produced. You can thank her for the movies Rocket Man and Hacksaw Ridge, and those are just 2 of many she has brought to us. Ms. Selig only talked to Anubis about a project known far and wide for years and years because Mr. Jonathan Brownlee of Anubis told her Anubis had an executed exclusive. This is not a he said, she said. This is a look at the contemporaneous emails and agreements case. In its NDA, let's look at that. With Selig, Anubis represented, Anubis is in the business of financing, developing, creating, distributing, and publishing visual content. And in answer to Ms. Selig's question, do you own that script outright? Do you own it outright? Anubis claimed to have an executed exclusive. In other words, the executed exclusive, Anubis claimed, was tantamount to owning Downslope outright. But Anubis had neither experience nor an executed exclusive. And Anubis tries to get around that in one way, not by looking at the contemporaneous documents, not by looking at the agreement, but by a statement in Mr. Brownlee's affidavit 4.5 years later that was filed in this case in July of 2018. And he says, executed exclusive doesn't really have any meaning. So King's X, We're not responsible for your reliance on the representation of an executed exclusive.
I want to interrupt because I got a question, and I guess this is for both of y'all. Is it your position that a slew of written correspondence, I mean, actual documents, can preclude there being a genuine issue of material fact, notwithstanding an affidavit that might be to the contrary of those written documents? In other words,
sorry, Your Honor. When that affidavit is so incredible that a reasonable juror is not going to believe it, as if it were testimony in trial, correct. You get a summary judgment on that. And this affidavit, for the first time, talking about an oral agreement that Ms. Selig willy-nilly gave $10.5 million to somebody that she barely knew, correct. That is it. And then you compare it against the contemporaneous communications, which I'll get into. You compare it against the documents, which I'll get into. You say there's absolutely no credibility to that.
Mr. McDowell, did you move to strike that affidavit as a sham affidavit?
I did not move to strike that affidavit, Your Honor.
Okay.
The statement in Mr. Brownlee's affidavit makes Anubis's fraud on Selig crystal clear. Under oath, he tells us that he purposely used meaningless words to convince Ms. Selig she had to go through Anubis if she wanted to produce downslope. But those words had big meaning to Ms. Selig, and reasonably so. Based on those words, and those words only, she talked to Anubis. And as we demonstrated in our papers, downslope was conceived by Mr. Stanley Kubrick in 1956. It has been widely known for years. There are hundreds, if not thousands, references to it on the internet. We gave you three. Three of them are in the record, and those are from 2010, 2012, and 2013. And all of those talk about Stanley Kubrick's downslope, its connection with Philco, its connection with the director, Jay Russell, its connection with Messrs. Lanning and Hobbs, all of which were the factors that Ms. Selig used to contact those people. Anubis was posing in both directions, and it blew up in Anubis's face when the other parties finally realized that what they were dealing with. At the beginning of February, after Mr. Lanning of Philco told Ms. Selig that Anubis has nothing really, and that's in an email, Ms. Selig shut Anubis out. Thereafter, Anubis represented to Mr. Lanning that it did not need Ms. Selig's money. So Mr. Lanning requested that Anubis show proof of funds. That was to demonstrate that Anubis actually could perform. They could come up with the $10.5 million recited in the LOI between Philco and Anubis. Anubis went radio silent at that point and didn't answer Mr. Lanning's request for proof of funds because there weren't any funds. Indeed, in an email from counsel for Anubis in this matter dated April 26 of 2018, in response to our motion to compel, we find out for the first time what the party's defendant discovered in February 2014. Anubis was unable to locate any communications related to the request for proof of funds. And now Anubis claims under that LOI, they were to come up with $10.5 million. They didn't have to show that they were capable of coming up with that money. But no, days after he sent her the LOI that no one ever signed, Mr. Brownlee said exactly that to Ms. Selig in an email. Quote, when we show proof of funds, POF is what he said, proof of funds, or commit to the financing, then she could see the chain of title. He knew full well that he had to come up with proof of funds. As I said, quickly thereafter, after Mr. Lanning asked for proof of funds, that was the last he ever heard of Anubis. And 3 weeks later, he severed ties with Anubis on behalf of Philco and said, look, you went radio silent. It puts in doubt your ability to even perform. And you've been giving me the silent treatment since February 5th, when I asked you for proof of funds. That was it. They were over with. And the posing continues to today in this very oral argument. One plaintiff appellant, Anubis, posed as the mover and shaker, proposed that they had the executed exclusive, but the reality is they were in existence for a couple of months when they signed that NDA with Ms. Selig, with that representation of what they are. And they've never conducted business. And during this litigation, they didn't even pay their franchise taxes. I had to file a motion to abate, and then they did file them. The other plaintiff appellant is CMA. This is the second CMA entity. It is different from the first CMA entity that was plaintiff in the first lawsuit. This second CMA entity, the one that is appellant here today, was created in California days before this case was filed in December 2017, and about 4 years after the operative facts in this case. The second CMA has nothing to do factually with this case. But the zinger on CMA, let's say two zingers, is CMA was actually canceled 8 months after this case was filed by the very individual who created it. And that's a process under California law. It's a California entity. It was canceled in August of 2018, 8 months after it was formed. This canceled CMA has had no legal standing to maintain suit since it was canceled in August of 2018. And the second zinger, here we are, 2 years and 2 months after CMA was canceled, and CMA is represented by opposing counsel. These points on CMA buttress Ms. Selig's proof of bad faith and harassment in this lawsuit. The claims are also fictions. Anubis claims against the Selig defendants for breach of an NDA. The NDA was signed on its face. It was signed November 18th of 2013. And it was as to aforementioned project. There's no aforementioned project in it. But if you look at the email that transmitted it.
Projects.
Sure, projects, sorry, Your Honor. If you look at the email that transmitted it, it talks about the Anna Kendrick and Chris Prine's Mantivities.
But it doesn't say that
thereafter,
exclusive, or
sorry, Your Honor.
I mean, does the email say that that's the exclusive project covered by this NDA?
No, but the word aforementioned looks into the past. And what have we talked about? We've talked about the aforementioned projects, and they want to bring that and make it apply to the future. And that was the conversations with the, that's the conversations with respect to downslope, which didn't start until January 10th, and then in earnest on January the 27th, 2014, 3 months later. The definition of the NDA, if you want to look at the NDA carefully, the definition of the NDA does not allow Anubis to impart information they obtained from a third party and claim protection of the NDA. To be confidential information, it has to be either party's creative properties, and that's on the face of the NDA. By the terms of the NDA, public information was not protectable, and we've shown you it's all public information. It's publicly available for everybody to see. No materials, if you want that NDA to apply, you have to put the words confidential information on it, again, by the terms of the NDA. No materials were ever marked with the words confidential information or anything like it. And they have to be so marked. The NDA has requirements including those words, and we don't have those words anyplace. Now, one very important part of that NDA is that Anubis claims applies here is paragraph 7, which is a paragraph that governs going forward. And that says, no obligation to complete transaction. Neither party is bound to proceed with any transaction between the parties unless and until both parties sign a formal written agreement setting forth the terms of such transaction. There is no formal written agreement that's been signed by the parties. It is an insurmountable hurdle to Anubis's own words and against all their claims in this lawsuit. And note, at no time before this lawsuit was filed, and that's the first lawsuit was filed, did Anubis ever claim the NDA applied to downslope. Anubis claims a second breach of contract action based on the unsigned LOI. Proceeding chronologically, the LOI is a letter of intent sent by Anubis to Selig via email. Please see the attached LOI for your review. Now, Mr. Brownlee, 4.5 years later, says they already had an agreement by that time, by the time the LOI was transmitted. But the transmission doesn't say, this is our deal, just sign this as a formality. It says, please see the attached LOI for your review. And by its terms on the face of the LOI contemplates a subsequent more formal agreement. It is an agreement to agree and nothing more. It was never signed by Anubis. It was never signed by Selig. An oral LOI or any oral agreement was never mentioned in any of the contemporaneous emails. January 27th, from when they transmitted to this lawsuit. In other words, there's all the emails at the time. They made demand in June 29th of 2014 against Ms. Selig, and they said, they didn't call it the agreement that we have. They said, it's the term sheet, sign the term sheet. And then in that first lawsuit, they didn't say an oral agreement at all. Literally, what they said is that they had a signed agreement. The letter of intent is a valid and enforceable agreement between Anubis and the Selig defendants. Under the LOI, the Selig defendants agreed to keep the LOI and the terms confidential and to be bound by the terms of the LOI. Not we had a deal, not we had an oral agreement, none of that. And this very lawyer dismissed that first lawsuit when he was confronted by the facts. And the facts were laid out in a letter from Ms. Selig's lawyer to the lawyer in this lawsuit. The facts were laid out in that letter. There were attachments. The attachments were the contemporaneous, the demand letter and other proof. And this lawyer dismissed that first lawsuit. In the December 2017 lawsuit, Anubis now alleges that while Selig and Shake and Bake did not sign the LOI with Anubis, Ms. Selig verbally accepted the terms. Again, Ms. Selig willy-nilly verbally said, I'll give you $10.5 million to the other side. Anubis breach of contract claims fail. The remaining claims fail too for these reasons and for the other reasons set forth in our briefing and the motions for summary judgment. And none of the claims were ever viable. The language of the MNDA that everything must be signed and in writing going forward is a hurdle none of the claims can overcome. The taint of Anubis's fraud on Ms. Selig that they had the executed exclusive was tantamount to ownership, which they did not have, effectively precludes these causes of action. At one point, opposing counsel cited a quote from Ms. Selig that maybe they deserve a finder's fee, but that was when she thought that she had to go through the Anubis to get to Philco, and Philco to the Kubrick estate, the Kubrick estate to the Downslope project. So that taint has tainted a lot of points that Ms. Selig has made, but she's not in any of this saying, you know, I want to cut these people out of the deal. It's that maybe you owe them a finder's fee, again, because she thought they had the executed exclusive, but not, I want to cut them out. Now, look, we have the only evidence in this record as to an oral LOI is Mr. Brownlee's affidavit. That is it. Lanning and Hobbs are just not subject to the jurisdiction of the court of the state of Texas. Case law is clear. The Texas Constitution is clear on this point. The standard for overturning Judge Moore's order denying Ms. Selig's motion for sanctions in this matter is abuse of discretion. Judge Moore's order, compared to the facts of this case, is so arbitrary and unreasonable as to amount to a clear and prejudicial error of law. Our judge declined to exercise her power of discretion vested in her by law when the circumstances of the case require that her power be exercised. If this case goes unsanctioned, the obligation on counsel to investigate this case and other cases is meaningless, and the ripple effect as to all unscrupulous persons following this case will be very dangerous. Everyone is free to ignore the documents, file suit, and harass persons. The documents are what we've brought to this court's attention in this matter. It is not he said, she said. They are the anchor to the facts. They tell the whole story. Now, I am telling you, Judge Moore is a tremendous judge, one of Dallas County's many fine jurists. But as you can tell from the briefing in the law, especially in the Dallas Court of Appeals, it is not the black letter law as represented by opposing counsel. It is that misrepresentation of the law that got between Judge Moore and granting Ms. Selig's motion for sanctions. And look, if we're worried about due process or somebody having enough time, he had 32 days. He had the affidavit. He had 337 pages of records, affidavits, and otherwise attached to it. And if the point is, we'd rather just go to court not knowing who the witnesses are going to be, not knowing what the exhibits are going to be, that makes no sense. So on every grounds, we've got the equities here. Now, the law. Statutory construction. Rule 13 governs the imposition of sanctions for abuse of litigation proceedings to harass by filing groundless pleadings. Similarly, Rule 215.3 governs the imposition of sanctions for a party's abuse of the discovery process. Rule 13, like Rule 215.3, allows a court to impose sanctions after notice and hearing. In the context of Rule 215.3, the Texas Supreme Court has ruled that the after notice of hearing language does not necessarily impart a requirement for a personal appearance or oral presentation. And that's the Sire case, C-I-R-E. And the courts of appeals have taken that case and run with it, where Rule 215.3 does not require an evidentiary hearing, neither does Rule 13. And that's the Santos versus Holtzman case out of Corpus Christi, Edinburgh. And then the same as to the Nath versus Children's Hospital case, that's a Houston case. And the holding was that the Houston Court of Appeals, the Houston Court of Appeals held that Sire eliminated the evidentiary hearing requirement in the Rule 13 context.
Mr. McDowell, you're out of time. Thank you very much, Mr. Goldfarb. Whenever you're prepared, you may conclude.
Your Honor, a few points with respect to that. This court has issued clear opinions stating that you must have an evidentiary hearing in order to make the evaluation of issues such as whether there is bad faith, such as whether there was an improper purpose, and those findings that are required under Rule 13. There is no evidence in the record to support that. While they may have attached affidavits to pleadings, those affidavits were not introduced into evidence. They are not evidence, and the court has previously held that affidavits attached to motions is not enough. They have to be admitted into evidence. That's the O'Donnell versus Vargo case, which Justice Whitehill wrote 2015 Westlaw 4722459. And there are other cases as well, which we cited in our motion papers, which were not distinguished. That ends the inquiry with respect to the issue on sanctions. A couple of statements that were made about the facts which are not supported by the record. One, there's an accusation that Anubis has no experience in the film or financing industry. This completely disregards Mr. Brownlee's affidavit, in which he goes through all of his resume of what he did, what his experience is, how many films he's made, and how many films he's currently making. He's currently the head of the Dallas Film Festival. Now, these are not people off the street who don't know what they're talking about. That's not what the record shows. The issue regarding CMA, The issues regarding CMA's corporate issues and corporate formation has nothing to do with the merits of this case, has nothing to do with the claims. There were no motions made as to standing. This is all outside the record and completely irrelevant. With respect to the issue regarding the email in which it states we have an executed exclusive to finance it for Philco. And a representation just got made to you that says that's the same as owning the script. Words have meaning. This doesn't say I own the script. It says we have an executed exclusive to finance it for Philco. And what that means and how that is an issue of fact for a jury to decide. Is that fraud? Was that a false representation? We contend it isn't. We did have an agreement with Philco to finance it through SCTV and CMA. That's what we were doing. Was it material? Was there some kind of detrimental reliance? Was there damage or injury? There's no evidence in this record to support that on behalf of Ms. Selig. None of that. This is all a fact issue. There's a claim that everything in this is public, that none of this was confidential. The script isn't public. In fact, when we were trying to engage in discovery, the record shows Ms. Selig talks about how important it is to maintain the secrecy of the script and how important that is in Hollywood. That script and the issues around it were confidential, and it was provided to her confidentially. She acknowledged that when she asked for permission to send it around. And whether or not there's a big stamp on the script that says confidential doesn't mean that the parties didn't recognize that it was submitted confidentially under the NDA. Argument here is that, well, Ms. Selig thinks that Jonathan Brownlee's not credible and he's a big fat liar and therefore you should just ignore his affidavit. I mean, that's just not how summary judgment works. If it's a sham affidavit, there's hoops you've got to jump through in order to do that. You got to file a motion and you got to get it stricken. That didn't happen. I'm sorry, Judge, I can't hear you.
This is Whitehill, you're muted.
I'm sorry, Judge, we can't hear you.
All right, sorry about that. I mean, is there a set of circumstances where written documentation, written correspondence can be so definitive that a contrary affidavit just does not create a genuine fact issue?
I think that that's the context of a sham affidavit motion, Judge. I think you got to move on that. I mean, or you can have, maybe there, look, if there's a statute of frauds issue, which says you can't consider anything that's not in writing, we've got rules for that. But I'm not aware of anything in the summary judgment rule that says, oh, if you've got a really clear document, but you've got an affidavit that says something different, you ignore the affidavit. That case hasn't been cited to me. There's a process for, if somebody if there is a sham affidavit in the summary judgment context, there's a procedure for that in the rule. We don't have that in this case.
Thank you very much, Mr. Goldfarb. Does anybody have any other questions?
No.
No.
Thank you so much. We really appreciate your excellent briefing and your argument. And again, we apologize for the delay. It could not be avoided and the case is submitted.